Welcome, everyone. If you're here for the Leandro ruling, what happened and what's next, you're in the right place. So glad to see everybody here. This is a really important topic, and our registration has been very strong. I was telling our panelists that I think this is a really good indication of how important this case is to North Carolinians and how much it means to us. So I'm really excited today. I feel like, I am getting a pass to a backdoor pass to a famous Broadway play. I'm so excited to have these folks here today. They are really the experts on this subject from a variety of roles and they've had over their careers. And I'm very, very excited to have them here. And would like to do couple of quick things before I introduce them. We are recording this, so it will be sent to you. The link will be sent, and we asked you to share it with your neighbors and friends afterwards. We are going to save some time at the end for questions and answers. We have someone monitoring the chat to kind of capture those, and we'll kind of answer as many of those as we can at the end. And we want to dig right in. I've asked our panelists to kind of divide this discussion in kind of four parts. One, a little bit of the Leandro background. It's a long, lengthy case, and we want to kind of summarize it for you. A lot of folks have been lost in all the history of this case. And so we're going to try to give you a good overview of that. And then we're going to look at the current ruling that happened in April where the case was dismissed. Next, we'll move to a small section on what possibilities lay in front of us in terms of what North Carolinian public education advocates can do. And then we're going to finish up with a recent member of the Senate to talk about legislative possibilities. So quickly, I want to introduce our guests, folks that I admire and have admired for a very long time. Ann McColl is going to kick us off today. Ann is an attorney and a state constitutional scholar. She has worked in the field of education law and policy since graduating from UNC Law. I noticed that she's also a Broughton High School graduate. So I think she shares that with a few other folks on the call. Her positions have included being the legislative director for the State Board of Education. She's been general counsel for North Carolina Association of Educators, where I met Ann, and she has been a legal consultant and director for the North Carolina State Board Association. She is the co-founder of a project, the Innovation Project, and you should look that up sometime. She has served as Associate Professor of Educational Leadership at UNC Charlotte and adjunct faculty for UNC School of Education and School of Law. And I'm going to go ahead and introduce everyone now so we can move quickly through our sections. Chris Brook, an attorney, a practicing attorney right now. He is focused on the areas of appellate advocacy, civil rights, and employment law, as well as constitutional law professor at North Carolina Central School of Law. He also earned his law degree from UNC School of Law, and he served on the North Carolina Court of Appeals until the end of 2020. Before that, he was an adjunct professor at Carolina Law and the legal director of the ACLU of North Carolina, where I met Chris at. We are also honored today to have Robyn Sanders with us, an attorney that practices law with Chris Brook. She's served as a judicial law clerk to Senior Associate Justice Anita Earls on the North Carolina Supreme Court. She is currently an associate at Patterson Harkavy Law firm, where she focuses on civil rights, criminal appeals, and employment law. Before joining this firm, she served as an assistant federal public defender in the Western Division of Pennsylvania. She has also worked as a voting rights counselor at the Brennan Center for Justice in New York City. And particularly thanking her for her pro bono work that she has done on the Innocence Project at Duke Law. She attended Campbell Law School and is a regular contributor to Slate Magazine, where she writes a lot about civil rights and constitutional law. Our last guest is the Honorable, we had a discussion about that, Graig Myers. He was a North Carolina senator till just recently, just a month ago. And before that, he was a member of the North Carolina House of Representatives. He is now the executive director of the North Carolina Justice Center. He's been there for just a few weeks, so welcome into that new role. We look forward to seeing his work continue. He did represent Orange Person in Caswell County. He is a trained social worker and longtime public school advocate. Throughout his legislative career, he was champion that we always look to be making sure that public education was being first in every discussion. He is a strong advocate for access to health care, economic opportunity for working families, and policies that strengthen communities. So we look forward to hearing his response today to legislative possibilities. So without any other introduction to this very experienced and trained panel, I would, Anne, like to turn it over to you to start. We're giving us kind of a background about what this whole case has really been about.
Okay, I'm happy to do that, Yvonne, and thanks for having me here with this great panel. Yeah, so when we think about what has this case all been about, I think an important framing is to understand that for the plaintiffs, the poor school district students in those poor school districts, this has always been a school finance litigation case. And it's a part of a framework of these kind of cases in this country. And in each of these cases, there's some basic elements that we can hang on to see what's happened in North Carolina. It starts with, is there a constitutional right to education? That becomes something that's enforceable. The second is, has there been a violation of that right by the governmental entity responsible for it as provided in the Constitution? The third is, if there's been that violation, is there a satisfactory remedy that's approved by the court? And fourth, has the court ordered that remedy and any enforcement necessary to make that actually go into work? So if we step back for just a moment, you can imagine that if you want to do school finance litigation, it actually would have made sense to first start with the U.S. Constitution, because if you got a ruling there of a federal right, then that would lay the groundwork for cases all over the country. And in fact, someone tried to do that. That was San Antonio versus Rodriguez in 1973. And the U.S. Supreme Court said, no, there is not a fundamental right to education in the U.S. Constitution. So that's what has led us into looking carefully at our state constitutions. A lot of us are more oriented to our federal constitution. So I just really want to underscore that what this has meant is that we have been looking for us in North Carolina at our state constitution. So we, like many other states in the South, redid our constitutions right after the Civil War. We borrowed some great language on the constitutional right to education from Midwestern states, and we actually added to that, unlike any other state in the country, a fundamental right in our Declaration of Rights, right there with the right to a jury of your peers, right to voting, right to free speech. So when we decided to have this case in North Carolina, we start with a constitution that looks strong. But we still had to take it to court to see what the courts would say about, first, is there a constitutional right to education? That would be something that could be enforced. And in 1997, our North Carolina Supreme Court said yes. And the language of sound basic education that you've probably heard, that's a part of their interpretation. Because these cases were happening in other parts of the country, in fact, that language and the broader definition actually comes out of a Kentucky case. So first ruling we get, we say, yes, there's a right. The Supreme Court sends it back to the trial court with some direction on how to go about looking for a violation. And we go from 1997 until 2004 in a process with the trial court. When it comes back again, now the Supreme Court is looking at other parts of this question. One is, are there any violations? Here, the Supreme Court got very picky and said, In Hoke County, one of the poor school districts that were plaintiffs in this school district, there were clearly violations by the state for at-risk students in Hoke County. Um, they refused to be very broad in this, even though Judge Manning had looked at a lot of things at the trial court level that were statewide. And so it went back to the trial court with further direction. They did, in essence, enhance the notion of the right to education by saying that Judge Manning was right, that a constitutional right to a sound basic education would include things like having quality teachers, quality principals, adequate resources. We have another opinion that happens around 2013 on pre-K, where the court actually finds that there wasn't a need for the court to order because the General Assembly had responded to this idea of children who are not old enough to go to school having constitutional rights if they need, and that if they need additional education at an early age, they should have access to it. So that's all in those first 19 cases filed in 1994, goes to about 2013. So we're almost 20 years into this litigation, and what we don't have, and again, if you think of the framework of this is school finance litigation, which is meant to affect everything in the state. We don't have something from the Supreme Court saying they see statewide violations. We don't have a comprehensive remedy. So the plaintiffs start pushing on trying to get the court to require a more comprehensive remedy. That starts with Judge Manning, but then he has to leave the case for health reasons. It's taken over by another trial court judge, Judge Lee. Around this time, Roy Cooper is governor, and he is willing to work with the plaintiffs. We start moving towards a new phase, and this is in that 2017 post. And ultimately, what we end up with from Judge Lee is a trial court decision that includes identification of statewide constitutional violations. So now we have the second thing that we needed, where we had the right to sound basic education. We now have statewide violations. He approves of a remedy in the court, and he first gives the General Assembly a chance to fund this. They don't. And so he then includes, as a part of that fourth part of how do you go about enforcing an order, he directs the executive branch to release surplus funds to cover the part that's not already in the state budget. That brings us to like the second half of this case. And that ruling gets appealed. And there are some machinations here. I'm not going to go through all the back and forth with the trial courts, and the state comptroller also adds in a case on this authority to order the executive branch to release funds. But we come to the November 2022 decision of the Supreme Court. And at this point, they are taking up these issues. And so we get an answer from the North Carolina Supreme Court on all four things. There is a constitutional right to education that's enforceable. There have been statewide violations by the state. There is a reasonable remedial plan in place, and the trial court does have authority to order the executive branch to enforce that. After that, that should have been the big moment in the case. After that, it should have just gone back to the trial court to fine-tune the amount of money since different budgets have been passed. But instead, we have a changeover in the North Carolina Supreme Court. So that 4-3 majority that had been in favor of this opinion in November 2022 is a very different composition come January. And they are receptive to hearing oral arguments to open the case back up. When they accept to open it back up, what they say is that the General Assembly defendant intervener suggested all sorts of issues. They chose the issue of subject matter jurisdiction, which was saying, does the trial court have the authority to address these sorts of claims, by which they mean these statewide violations, these statewide remedies? That was argued in front of the Supreme Court in February of 2024. And we have waited until April 2 to get a decision about that. And I think that's where I stop. Is that right, Yvonne?
I think that's really a great overview, and it's such a complicated 30-some year case, and you did a remarkable job and getting to the core of it. And so, Chris, what really shocked the community, the public education community, was when this case was dismissed. Um, can you kind of walk us through what happened and what the judges of the Supreme Court said, and help us understand this ruling a little bit better?
Yes, absolutely. And good afternoon to you, Yvonne. I just want to say thank you to you for bringing us all together for this incredibly important conversation. You've been just a peerless advocate, but also just done an incredible amount for the discourse on these issues. So I know I speak for everybody when I say how appreciative we are for your contributions here. And also thanks to everybody who's joining us and taking some time out of their busy day to learn a little bit more about the Leandro litigation and the recent Supreme Court decision. As is always the case with these sorts of discussions, I learned a lot as well. And I learned that Anne and Robyn, my law partner, and I all went to Broughton, which I did not know. I have a strange feeling Robyn went to Broughton a little bit after I went to Broughton, but we don't need to dwell on that today. But I actually think that's an important and interesting place to start. We're not coming at these issues as some sort of intellectual issue. We are coming to these issues as public school graduates. My family moved from Georgia to North Carolina in 1991 because North Carolina had a better public school system than Georgia did in 1991. And my mom wanted to be a part of the North Carolina public school system, wanted her kids to be able to take advantage of the North Carolina public school system. And I think it's a question whether that's still true, that North Carolina has a better public school system than Georgia. But it's also why we're so engaged and so involved in this litigation. We prospered immensely from going to excellent public schools like Broughton. And we believe everybody in the state of North Carolina, regardless of their zip code, should have access to the same high quality public education that we had at Broughton. What I'm going to do today is talk very briefly about what the recent, what I will call Leandro 5 decision said, what it did not say, and then some outstanding questions that remain after Leandro 5. And I want to sort of inoculate myself at the outset here. I am going to spend a lot of time summarizing Chief Justice Newby's majority opinion. And that requires just sort of, in large part, saying what Chief Justice Newby held and wrote in Leandro 5. That does not necessarily connote agreement with that. And on occasions, I'm going to note what the dissenters had to say about particular issues, but I do think it's important to situate all of ourselves, with what Leandro 5 said as we think about what next steps are and what the path forward is. So what the Chief Justice's opinion in Leandro 5 said was that this case, and picking up a little bit where Anne left off, this case began as a local case. This began with particular school districts in the eastern portion of the state. And Chief Justice Newby said at some point, it changed. It became a case about seeking a statewide ruling. Students are not receiving a sound basic education and seeking sort of a commensurately broad remedy, which was sort of the West Ed or Leandro plan that Anne alluded to previously. Obviously, that was hotly contested. Justice Earls and Justice Riggs in particular in their dissent say, listen, this case was always about the state's responsibility to school children across the state. And but what Chief Justice Newby said is that in morphing from a local case to something broader, the court lost subject matter jurisdiction. He said, a court may adjudicate a controversy only when a party presents a controversy to it, and then only when it is presented in the form of a proper pleading. He said that the failure to essentially specify that this was the purported failure to specify that this was a statewide case, why that was problematic is because, he thought it had negative implications for sort of due process for all of the parties and fundamental fairness. He said that a pleading with claims and remedies being pursued is necessary to notify the adverse party of the nature of the alleged wrong and the relief sought. As I think Anne's comments alluded to, and certainly as Justice Earls and Justice Riggs' dissent make plain, you would have had to have been living under the largest educational rock in the state of North Carolina to not know what was going on in this case over the course of its 32 years. And the legislature was very well aware of the proceedings in front of Judge Lee that led to the West End report. The court, Chief Justice Newby, also suggested that this became at some point a facial challenge to the educational system as opposed to an as-applied challenge, and therefore it needed to be heard by a 3-judge panel. Again, the dissents, I think, do a very good job of sort of explaining how problematic that assertion is. First, when this case was filed in 1994, there were no 3-judge panels in the state of North Carolina. And even if it were true that this case needed to be heard by a 3-judge panel, that would not necessarily warrant dismissal of the case with prejudice, essentially ending the case for all time. Also, Justice Earls does a very good job in her dissent of highlighting that the litigants here followed the procedure that the court had laid out for them. The Supreme Court repeatedly, passed the case to Judge Manning at the trial court and then subsequently to Judge Lee, said, proceed on your claims in front of these trial court judges. At no point did the Supreme Court, prior to the decision earlier this month, suggest this needed to go to a 3-judge panel. In fact, quite the contrary. There's also sort of a real hat tip to sort of Jack Boger here for flagging this, but there's a real conceptual problem here as well. Facial challenges and the notion you need to bring a facial challenge is really a concept that's more applicable to statutory or regulatory challenges. There's no discrete statutory or regulatory challenge that the school districts and the students are bringing here. They're instead sort of challenging the fact that the legislature has failed to act. It's a totally different sort of litigation. So the consequence of these conclusions, Chief Justice Newby and the majority says that all proceedings in the case prior to April 17th, 2017 are void and dismisses the case with prejudice. So, I think that's what Chief Justice Newby's opinion said. What did it not say? And I think that's incredibly important for us to understand as we plot out and think about next steps. And as people who care about public education system in North Carolina, I think it's incredibly important that we understand what the opinion did not say. The opinion did not say, it did not overturn that there is a state constitutional right to a sound, basic public education that every school child in the state of North Carolina is entitled to. The opinion did not say that that sound, basic public education right is unenforceable, that the courts can play no role in enforcing that constitutional right. And listen, this is sort of, what the dissents focus on. If you have a constitutional right, but there can't be a remedy to enforce that right, then that right is just a paper promise. And making it real for school students across our state is sometimes, as this case highlights, incredibly hard to do. So rights have to be enforceable. Leandro 5 does not change that courts can enforce the right to a sound, basic public education. It also did not say that courts cannot order the payment of funds as a remedy for a constitutional violation. Courts, as Justice Earls flagged, do that all of the time. There are occasions where the government violates your constitutional rights, and the remedy for that is that the government has to pay up. Leandro 5 and Chief Justice Newby's opinion does not change the fact that that remains good law. But, and I don't want to be too jargony here, there is tons of dicta in this case, non-binding, but it's sort of advisory statements from Chief Justice Newby and the majority about the law, and some of that dicta is frankly troubling. Chief Justice Newby at some point says that people did not vest the judicial branch with the power to set education policy. Okay, if you define that narrowly and say, yeah, obviously the legislature and the executive branch are going to be the parties who have the first and principal responsibility for setting educational policy, then I think that's a totally unproblematic statement. But here, in the context of saying we're going to undo a remedy in the face of decades of failures from the legislature to live up to a constitutional guarantee, I think the concern is saying that we will not ever enforce a remedy for failure to provide a sound basic education, and maybe even viewing this case as sort of non-justiciable. Courts should not be involved in these sorts of cases, despite the fact that the Leandro litigation has made very clear that courts can and should be involved in enforcing this particular constitutional right. Finally, some outstanding questions that are left after Leandro 5. First, there was Leandro 4 that Anne made reference to, where the court said, the legislature has failed long enough. They now have to step forward and pony up to support our public schools. What remaining force does that ruling in Leandro 5 have? Obviously, it's no longer the controlling law, but is it persuasive authority that can be cited to by litigants going forward? Chief Justice Berger, in his concurrence, believes that it is. He says that the reasoning of Leandro 4 remains as persuasive authority. And that's a large basis for the difference between Justice Berger's concurrence and Chief Justice Newby's majority opinion. Justice Berger is explicit about this. He says, to be clear, I would not write separately if the lead opinion declared, everything after April 2017 void and expressly disavowed the reasoning in Leandro 4. The court did not expressly disavow that reasoning. So the biggest unanswered question is, what sort of litigation could survive this Supreme Court ruling that preaches deference to the legislature, but also is troubled by the fact that the original students are, not still involved in the litigation. So, move slowly so that the legislature can fulfill its responsibilities, but move so quickly that you're litigating on behalf of the original students who are involved. That could result in a catch-22. Justice Dietz, in his dissent, suggests maybe class actions are the way of proceeding in the future. But the point I'll leave with and close on is that Chief Justice Newby's Leandro 5 opinion is so sort of intellectually and conceptually undisciplined, featuring so much dicta, that the next opinion written by the Supreme Court on the right to a sound basic education is going to go a great distance to defining what that right means and defining how enforceable it is for students in the state of North Carolina.
Okay, and so Robyn, this kind of brings us to the question of the day. A lot of folks, myself included, when I saw the dismissal, felt so dejected, like, okay, it's over. Without prejudice, what does that mean? Well, we quickly learned that meant case will not be heard, cannot bring it back, it's over, blah, blah, blah. But what is the future for public education and enforcing the constitutional right to such? What can happen next? What do you think are possibilities that the community of public education advocates can can think about in terms of trying to rectify this huge funding inequity that's going on in our school system across the state?
Yeah, so I think answering that requires me to kind of go back and piggyback off of what Anne and Chris said, which is, again, starting with the legal framework that the court is using. And as they said, the court majority draws a distinction between as applied and facial challenges. And I think that the audience can think of as applied challenges, again, as a question of whether the Constitution is being violated here in this place for these school children. And then a facial challenge asking, is the system itself unconstitutional everywhere? And I think, again, as Chris pointed out, the court says in its opinion that this lawsuit began as district-specific claims, and over time it became something entirely different, a statewide challenge, and that it wasn't formally pleaded that way. Therefore, the court has no power to entertain this case at all. But I think because of that shift, the court says, you know, we can't hear this case and it has to be refiled in a different way. So I think that framing, though, is doing a lot of work. And I do think it's important, again, to say that I'm sure I'm speaking for everyone on the call. I disagree with that framing. I think it's at best wildly incomplete. And I think at worst, it's really intellectually inconsistent with the reality of how this case has developed over decades. It's hard to square that this is a facial challenge when it's clearly just a case that Leandro hasn't actually been litigated that way. It was built case by case. It involved districts by district, and it involved plaintiffs showing real world failures and specific harms as it related to specific students and in specific districts. So I think it's not entirely clear to me how that characterization fits with the record in the case, but I think it's important for purposes of answering this question that this is the framework that we now have. And I think, again, unless the composition of the court changes or the doctrine shifts in some way, I think we have to assume that the court means what it says here and that they will apply this reasoning going forward. So I think the question really is, how do litigants operate within that reality? So I think one way is as applied claims. So I think the clearest path to me is proceeding through what we call as applied litigation. So in plain terms, that would essentially just mean that litigants would bring a case that's grounded in specific localized harm. So I think making it concrete for the court. So for example, imagining Beaufort County, which is a district that's near and dear to my heart, where my grandparents live, where my mother grew up, a very poor rural county. So for example, plaintiffs in that case could come to court and say, there are a myriad problems that demonstrate that this particular right that we have in the state constitution is being violated. There are persistent teacher vacancies in core subjects. There are students who lack access to basic coursework and to broadband. There are facilities that are old, decrepit, unsafe, and inadequate for any kind of learning to go on whatsoever. And maybe saying that the outcome data that's been studied by different groups shows that students in this particular district or county are not even meeting minimal benchmarks across a host of just traditional criteria, reading, math, science, you name it. So I think what would happen is an as-applied lawsuit would essentially say, for the students in this district, the state is failing to provide the opportunity for a sound basic education guaranteed by the state constitution. And it would also include a detailed factual record, which again was what happened here, but of course the court disagreed. But it would include testimony from educators in that particular district. Like I said, data on the student outcomes that show how these deficiencies are actually playing out on the ground and impacting the ability of students to have the promise of a sound basic education, evidence on resource gaps, and expert analysis, of course, trying to tie those gaps to the constitutional harm that they want the court to identify. And then in an as-applied challenge, the plaintiffs would be asking for a specific and targeted remedy. So for example, if they identify that there are staffing issues that bear on children's ability to get the basic education that they're entitled to, then a remedy would say, we want to address staffing in this concrete way. Same with the resources. If there's a gap or some evidence of resource gaps that's presented through evidence heard by a court, then one of the remedies would be, okay, we need to increase the specific resources that we've identified are are missing for these children in this particular district. Same with deficiencies that are addressed in the ways that I said by expert analysis. So it would be saying, here are the specific concrete deficiencies that we have identified as plaintiffs, and here's the remedy that we're asking, which is tailored and specific to the identified violation. And I think that that kind of claim would fit squarely within what the majority here says remains permissible. I think another option, I think, is, properly filed statewide challenges before a 3-judge panel. So it would need to, in the pleading, state expressly that we are in fact raising a statewide challenge. Or if you want to understand it, again, I've explained my issues with the reasoning as a facial challenge, do so, but explicitly in the papers or pleadings that they submit to a court, explicitly say, this is what we're doing here. We're not seeking for, the court to understand this as an as-applied challenge. We are specifically pleading that this is a statewide challenge, and here are the reasons why. And then I think also, of course, you have legislative and administrative advocacy, which I know that Senator Meyer will discuss, but I think that's always an option. And, while it's perverse to me, it somehow plays into what the majority is saying here, which is, although this is a constitutional right, it's essentially unenforceable in the legal process, and it has to be enforced through a political process, which means legislatively. And again, I think there are many disagreements that I and others on this call have with that sort of argument, but adopting, and taking the court as it is and as what it's saying, another avenue, I think, would be just continuing to try to press for legislative changes through advocacy. Now, of course, there's another decision of this court that makes that remedy or that sort of avenue harder, which is the fact that this state has greenlit gerrymandering, so that even if voters want to go to the polls to vote in people who they know care about this issue and who will address it accordingly, it's increasingly difficult to do that when we are living in a state where the legislators are choosing their voters and not the other way around. Also attributable to this court's failures and its sort of, I think, erroneous interpretation of the state constitution and guarantees that are in it. But nonetheless, I think that's still something that is a pathway that's available. And, as Justice Earls always said, who I clerked for, it's, high turnout can defeat even the most savvy gerrymander. And then finally, I think potential federal claims, although those would be more limited, I think are potentially on the table. And I also think perhaps inequality-based litigation. So we may also see cases framed more explicitly around disparities, so racial inequities. So this is compounded, right? Like the Leandro problem doesn't just impact, if you sort of filter down, it's not only a problem statewide, but then when you filter down across demographics, it's actually harming African Americans and children of color at disproportionately uneven and serious rates. So racial inequities could be a cause or a claim that could be brought. I also think wealth-based disparities between districts, which again, I think is sort of could be captured in like an equality-based or style litigation. And then again, unequal access to resources and opportunity, again, framed in those ways. And I think the claims, the federal claims, as I was discussing earlier, I think could be brought under both the state constitution and federal civil rights laws, depending on how they're structured. But I think importantly, though, they can draw on the same factual reality that Leandro did expose. So I think there are still paths forward. I think they require not just proving harm, but I think, and again, which has been proven many times over, but I think it requires navigating a court that has redefined how and whether the harm can even be remedied at all. And I just want to say too, I think all of these pathways assume that the court will apply its reasoning consistently, so that if litigants follow the procedural rules that have been laid out in this opinion, that their claims will be heard on the merits, meaning substantively. But I think that assumption, I think advocates have to operate under is, the concern is that I think the tension, this is what you see reflected in Justice Earl's dissent, is that whether these procedural rules have actually become moving targets in a way that makes enforcement of the right itself pretty much impossible. So I think even though I assume new lawsuits are coming, and I assume that these kinds of lawsuits are ones we will see now as a result of this opinion, I think they're still having to be brought in a legal environment where it's not just the substance of the right, but the stability of the pathway to enforce it is very much in question under this court majority, which is why it's so important that everyone vote in statewide elections for judicial races. Because I think if there is a change in the composition of the court and the ideological bend that this court has, then I think you'll have a much more hospitable environment for bringing even these types of claims, which this court says are permissible. But, sadly, all of this sort of asks litigants to accept at face value what this majority says. And this is a majority that's been known to be internally inconsistent, intellectually dishonest, and continues to create new moving targets with new litigation. But again, I think we have to accept the landscape as it is right now. And so those are some of the pathways I think that are available for litigants as they think about how they might, gin up or regenerate this litigation in the future.
Excellent. Thank you so much, Robyn. And one of the and we're going to go ahead and let Senator Meyer have a few moments to chat with us because we've got some great questions coming from these presentations so far. But all of this feels kind of daunting, right? We listened to what Ann has said. We listened to what Chris had to say about the dismissal. Now Robyn saying, this is not going to be an easy task. There's still a lot of barriers to finding a way for, equity and a sound basic education for all the children in North Carolina in our public schools. So it feels kind of daunting, but Senator Meyer, you came from the House, you came from the Senate, you're now in an organization that is, always been a staunch supporter of public education. What about the legislature? I mean, why are we dealing with all this? What are the responsibilities of the legislature and what can they do? What do you think we should do?
Yvonne, thanks for your leadership on this. Thanks to Public Schools First North Carolina for being a part of this valuable coalition. And I'm going to answer your question, but I want to say this one additional piece of reflection. I think that it's been amazing how we've had such coordinated discipline strategy around Leandro with so many players over such an extended period of time. I think that hearing from Ann and Chris and Robyn, you hear the disciplined strategic thought on the litigation side. I think that on the community organizing side, Public Schools First and every other member of the Every Child Coalition made sure that all of the organizing and advocacy was directly aligned with Leandro. There's not many experiences that we've had in North Carolina where we've had so many players lined up so directly and so clear on what their message was and what the intended outcomes were over the last 15 years since the General Assembly swung to this new conservative era. Unfortunately, as we all know, that level of discipline hasn't resulted in the impacts that we want, both because of the ruling in Leandro 5 and because of the failure of the General Assembly. Because the best that we could hope for under Leandro was actually better than forcing the executive branch to do the legislative branch's job. The best that we could have hoped for was for the legislative branch to do its job. And that is still where we are today, even more so possibly after Leandro 5. It is the legislature's duty to fund our schools. And the idea of fully fund is, of course, a completely debatable provision. What does fully fund mean? Does it mean what was in the Westlaw report? Does it mean something different than that? It will always be debated. But ultimately, the power to solve our challenges with public schools starts with the legislature and then extends into the executive branch's leadership, and then should be remedied in the courts when those two branches fail to meet their duty. So when I listen to Ann and Chris, and especially what Robyn just said, what I realize is that we've been narrowly and appropriately targeted for a long time. And now we need to keep the strategy and keep the coalition and keep the creative thinking, but consider a much wider range of strategies. wider range of strategies in the litigation space, but also a wider range of strategies in community advocacy and trying to push the General Assembly to do a better job of funding schools. And I would emphasize that that doesn't just mean asking for more, that it means we have to be just as disciplined and strategic about helping North Carolinians understand that part of the reason why we can't fully fund our public schools is because the General Assembly is hell-bent on limiting our revenue sources by eliminating the corporate income tax and dramatically decreasing the individual income tax, and now potentially reducing county property taxes, which is the other main source of funding schools. And so they're putting a throttle on what's even possible before we can demand that we do what our kids deserve. So we have to be ready for a new era in the North Carolina Justice Center, where I'm so proud to be now that I've left the doldrums of the General Assembly behind. I fully intend for us to continue to be one of the coordinating organizations on what comes next. I don't know yet entirely what that looks like, but here's one thing we've talked about and that we imagine. We think maybe getting to this fall, get past legislative short session, give everybody a little bit of break over the summer, and we get to this fall, could we reconvene so many of the Leandro-focused allies? And I think about three groups that in particular that have to be convened. One is the litigators, for sure. Like, you all have a special responsibility. The second falls kind of under the lens of the Every Child Coalition, of which the Justice Center is one of the two primary coordinators of all the organizations that care about coordinating citizen advocacy and public advocacy. And then the third group, I think, is business and other allies. Those folks who have a vested interest in the success of our public schools, but don't fall in kind of the citizen advocacy lane. And I think that all three of us have to have a coordinated vision of what we're going to try. It doesn't have to be as narrowly focused as we were under Leandro. It can be very broad and experimental, but we have to all know, like, here's what we're working towards. And then everybody has to know their lanes, and we have to have coordinating organizations for each. And we have to do something that wasn't intended in Leandro, but happened and worked, which is we need a plan that is longer than a legislative session. We need a plan that thinks about where do we want to be by the time we get to 2040, which seems impossible today, but the truth is that's the only way that we can get to where we need. And in that plan, I think we have to consider what are the immediate asks of the legislature and what is most likely to get funded under the current legislative majority, what is possible to get funded under some different configuration of the majority, whether that's a Republican majority but not a supermajority, or whether that's split power, or whatever it is. But where do we start? And then where do you build on from there? What do you want to get to eventually? So, for instance, one area that would be a prime legislative target in the short term, short to medium term, would be, can we lift the artificial cap on funding for students with disabilities? It was called for in the West Ed report. There is bipartisan support for that in the General Assembly. We don't have to eliminate the cap. You could just increase the cap and then have additional funding for students with disabilities, which would be one major student population that we could support by just making that one move and making sure that it was funded. Are there other things that we could do that we think the legislature would be likely to do in the short run? There's always conversation about shifting the funding formula to a weighted student formula. It's really hard to do. It might cost a lot of money, but does it give us the opportunity to open new opportunities for funding? Are there other specific policy allotments under the current system, like the allotment for students who are learning English, where you could change the formula in order to get more to certain student groups? I think we can work on all of those things, and I think there's possible victories if we are strategic and disciplined about it, and we put the right pressure on the right set of legislators. The one piece of Leandro that I still am worried the most about at the legislative level, and wonder if it will always require being addressed through litigation, is I don't know if this legislature will ever adequately take care of the poorest counties in the state. And it may take some creative thinking, like we may have to do what some other states do, where you run more of your funding through regional education service authority rather than individual district authorities. But it's really hard to make up the tax difference between what a Wake County can do with its ad valorem local taxes and what small rural poor counties can do. Only the state can solve that. And it would require some big ambition and some big dollars from the General Assembly to really balance out our rural county spending with our large affluent county spending. That's a tough commitment, one that we should ask for. I'm not saying don't give up on it, but one that might deserve the external pressure of additional litigation to try and force some of it. I'll stop there. I'm happy to take more questions of what's possible. I'll say one more thing. I certainly hope we'll get a budget in the short session. I don't think everybody knows whether we will. I do think if we do get a budget in the short session, it will include provisions moving starting teachers closer to the $50,000 a year level, which is a huge victory. And kudos to all of us who have worked for increasing teacher pay as part of the Leandro work. We have gotten some victories there, and let's hope for another one this year.
Excellent. And let me just quickly turn to a few questions. One of the things that we've had a couple questions on, any one of the panelists, feel free to answer. But, is there a way to use what we learned from Leandro to have a case to support better students with disabilities, to fund special education better? Is there something we can learn from this case that we could move forward to say that this is certainly a special group that is not receiving a sound basic education?
I'd be glad to say something to get it going. One of the things that Justice Dietz said in his concurrence, which, he's one of the not concurrence, dissent. He's one of the 5 Republicans, but he refused to go along with them. And it was in part that he thought that there were ways to work through some of these procedural issues. And he offered up the idea of a specialized, streamlined class. And, what do those words mean? Who knows exactly? And that'll take litigants a while to figure out. But I think the idea, Robyn was presenting different ways to think about the cases. One is to think about a group of students like children with disabilities, English language learners, people who, regardless of where they live, they experience education in a similar way and have similar challenges with the resources provided. So I think that is an opportunity that we can be exploring. And one of the, I really loved what Graig was saying about the networking and how we can all work together on some of these things. One of the groups that have been a part of some conversations are the law clinics at Campbell and Duke. They're children's law clinics, so they see these cases. And so, there are lots of ways that we can go about reaching out and considering how to do those cases. Judge Manning early on was not interested in special ed, so that's one of those things on the floor of the courtroom, but it's there to be picked up. And I saw in your Q&A someone, worry about how you do the finances so that you don't incentivize pegging children as being more disabled in order to get more money. So, there's things that have to be figured out. But yes, I think that's a possibility that litigants will be considering.
Okay. Anybody else want to add?
Just
Chris?
to piggyback on what Ann was saying, there, is arguably a sort of a fair amount of strategic wisdom to, the next case or cases be a little bit more bite-sized, right? To focus on particular classes of students, or to focus on school districts that face particular challenges and might have common challenges. That being a way to leverage some of the things that Justice Dietz said in his dissent, where he did hold open the idea of there being more localized challenges that he would consider. I think it would also be a way of, and again, want to stress that the majority opinion from Chief Justice Newby is sort of all over the place in regards to a lot of things. So subsequent opinions are going to be incredibly important to whether the sound basic right to sound basic education is fully enforceable. But so that sort of bite-sized litigation focusing on particular classes of students or particular school districts might be a way to deal with some of the concerns that Chief Justice Newby's opinion raises about sort of very, very broad, sweeping, statewide litigation. Focusing more narrowly might be a way to pick up some of the things that Justice Deetz has put down, but also allay some of the concerns that are laid out by Chief Justice Newby in his majority opinion.
Now, to the panelists, you can all see the questions in here too. If you see a question that's in there that you want to address, please jump in. I'm going to try to get through these and everyone welcome to stay on as long as you can. We'll try to get through these 4 or 5 more questions. To Ms. Sanders' point about, you see this one, seeking federal relief. I have also suggested for some time that we should consider a claim under the international human rights law relative to education. This would primarily be a means of raising the profile of the case in North Carolina, but I wonder about this as also a legal strategy. What are your thoughts, Attorney Sanders?
Yeah, I don't know that it would be a legal strategy inside U.S. courts. My understanding is that like most international education rights, like those in treaties, are not self-executing in the United States. I might be wrong about that and others can come in, but I think that generally means you can't just walk into a court and say, in North Carolina federal court and say, enforce these international treaties directly. So I think if the question is, will that get a judicial remedy for students in North Carolina? I think the answer is probably no. But I think it's still important though, I guess, in terms of framing. So I think if you could situate maybe in your brief what's happening in North Carolina with a global human rights context, and maybe highlighting how the United States is out of step with widely recognized norms around education, maybe it could be persuasive, but I think it would be less suitable for, I guess, Leandro type of litigation, and more as like a parallel strategy. So maybe like, international human rights framing for moral clarity purposes or for persuasive value, but I don't think that it would be a move in a North Carolina court directly that could shape any sort of remedy or the court's understanding of the violation, but others should disagree with me if they disagree.
There's a question here. What would it take? How could we create enough pressure on the General Assembly to consider a foundational needs-based model like Chapter 770 funding model in Massachusetts? Greg, do you have any thoughts on that? You sat in those seats and talked about how to fund everything in our state. You mentioned briefly some things about that, but has there been any real conversation about changing the funding formula in a way that's fair and equitable?
So there have been 2 big go-rounds just in the last decade on changing to a weighted student funding formula, which can be, it's not necessarily, but it can be more equitable. The people who really work deeply on the current allotment formula can also make strong arguments for why it's an equitable formula. I think Anne probably worked on it a bunch, like, Jerry Hancock worked on it a bunch. But if you switch to weighted student formula, it does open the door for thinking about things and putting different emphasis on different things and making sure that you have a system that individual kids feel like to a school district that your students' needs are getting funded. The challenge with switching from an allotment formula that we have now to a weighted student formula is one clear big challenge, which is adequacy. If you wanted to hold no district harmless, you would have to add several $billions to the overall funding of public schools. I'm all for it. If switching systems got us to several $billions of more funding, yes, we can figure out how to switch the system. But the last time the General Assembly went round on this, that's what stopped it from taking action, because there wasn't the will to add at that point, it was going to be like $3 billion. And so I hope there will be a day that we're willing to. It's not today, but we can work on getting there. I have to sign off, everyone, but thank you for having me.
Thank
Yvonne.
you so much. And I will say one last question. Good. Thank you for coming. I appreciate you so much. And the kind of the last thought here is that a lot of folks are mentioning and Senator Meyer basically said it too. I mean, some of the rural counties are really struggling. Is there some suggestions or thoughts on how we can engage rural counties in this advocacy, or is there a case to be made where we look at the inequities between rural and urban counties, even things such as teacher supplements and those kind of things, spec ed services? Any thoughts on that from anyone?
To say something quickly, since I spoke before. So I think on that equity versus adequacy, I would just kind of remind everyone that, the courts have already said equity isn't the issue per se. Like, because we do allow in our Constitution for counties to supplement, that's okay. What I think you can still think about is that in some of those rural counties, what they have isn't adequate. And so it's just framing it still in the notion of a sound basic education. It's like what Robyn was talking about. If you picked Beaufort and said, we don't have enough teachers to open a class, the school year kind of thing.
Okay, it makes really good sense.
I just wanted
And
to add one
go
more
ahead,
thing.
Robyn.
One thing that we haven't really talked about, but the court didn't really address this because they ruled on jurisdictional grounds. But one concern I have is about, like, let's say that there's a properly pled lawsuit and as applied challenge, Beaufort County. The court didn't say this, but it seems that it's lurking in the background about whether certain remedies can even be ordered of the legislature. So I think like the separation of powers issue concerns me, because it seems like this majority is poised to say, let's just take it as like there's a statewide challenge that's filed. The violation is proven. I could see this court saying, well, it's properly pled. We understand that this is the kind of lawsuit it was. We're not going to kick it on jurisdictional grounds, but what we're going to say is that the remedy that's being sought cannot be issued by this court because we cannot tell another branch of government how to operate. We cannot tell the legislature that it has to shell out X amount of money to correct the violation. So I just worry about that issue. And again, I think the court avoided the separation of powers holding by resolving the case on jurisdictional grounds. But I think the concern about courts overseeing statewide policy is clearly driving the analysis. And so litigants who are thinking about this, I think, need to think about that as well, which is, even if we can survive or get around the jurisdictional defect issue that they're saying characterized this case, how are we going to, I guess, prevent or stave off an opinion of the court that says, well, now you've proven the violation, you've pled everything correctly, but this court is not going to and cannot issue the appropriate remedy because because the scope is too massive, or because we cannot, as a court, tell a legislature what to do because it would be encroaching on another branch of government. So that's just something I thought about. And it's another, I think, issue that litigants have to be considering, even if they properly plead their lawsuits going forward.
Okay, in the spirit of ending on time, I want to give Ann and Chris maybe a chance for any closing thoughts.
Well, the closing thought that I'll make actually picks up on the points that Ann and Robyn were just making, which is that, when this litigation was originally filed in 1994, the lead school district was Hoke County, a heavily rural school district. And the four other counties that were involved, not necessarily as rural. Cumberland County was involved, Fayetteville, a big city, but heavily rural school districts as well. So point being, this is not a new problem, that there are particular school districts and particular students that are going to face challenges that are different than school districts in more affluent portions of the state. Rob Leandro, the named plaintiff, now an attorney, talked about part of the reason that he brought the lawsuit with his parents originally is they had to watch science experiments being conducted by other students in other school districts because they didn't have the resources in Hoke County to do those science experiments themselves. And so first, the rural challenge has always been a challenge. Second, I think our focus needs to remain on the fact that there are pockets in our state where there remain real funding challenges, and there are too many students who are being left behind. And I think to sort of Senator Meyer's point that he was making previously, we need to be communicating very clearly that the state constitution guarantees everyone a sound basic education, regardless of where they are born in North Carolina, regardless of the zip code that they live in. All of our students in North Carolina schools should have the opportunity to thrive. And that at bottom is what this litigation is about to me.
Any last comments, Ann?
On an up note, which is this has been, a 30-year litigation, and there have been other issues around the constitutional right to education, claims that could have been filed, and litigants were sort of respectful of the courts in this case. And also it's like it was a little hard to litigate something with this case looming with unanswered questions. I actually think we're in a really great place right now with the kind of coordination we can do across litigants, across advocates, and public policy folks. And we get sort of a fresh start. And I really encourage us to be working together. I love Craig's idea of bringing everyone together. We can come up with a really great set of strategies of moving things forward. So that's sort of, whereas this case was a very big case and it was heavy and difficult, I want to encourage us to think about being nimble and moving the bite-sized litigation, get out there, start doing things. You're on mute, Yvonne.
I don't know how we can say anything better than that. And that's a great way to end. And I do think thanks to our panelists of very passionate, knowledgeable, dedicated public servants who've worked in this area all of their careers and are still engaged, and we appreciate that. We know that this case is really disappointing in some ways, but like Ann said, we now have a clean slate. We can learn from what we have seen in the last 30 years. We can learn from this current court. We can certainly think of a path forward. And I think there will be plenty of those opportunities. We're going to be there, but I think I want to end from our side, Public Schools First positivity, in that everyone has a role to play now. It is very important for us to hold our legislators responsible. They really have the responsibility for funding our public schools. So, we can turn now to remind them that this is their job. We can also do what Robyn and Ann and Chris and everyone's kind of mentioned, which is we can be strong public education voters. It's important for us to find out where our candidates stand, what they believe, what they would support in terms of public education funding and our educators, and that we choose our candidates and use our vote wisely to make sure that we're electing candidates that will enforce the Constitution and the constitutional right of every child for a sound basic education. So these are all the ways that you can connect with us. Please get our newsletter, go to our YouTube. This recording will be there. Please share this with your friends. We will be back. We're going to probably be picking on these panelists again sometime in the future. We're going to keep talking about funding our public schools, supporting our teachers, and making sure that our state is prosperous because our children are getting the education they need to be successful citizens in this country, in this state, and in their communities. Thank you all a lot for coming today, and we will be talking to you soon. Thank you, Chris, Robyn, Ann. It's been a pleasure.
Thank you.
Bye, everyone.
Bye.
Great to be with you.